I don't think I've ever done this where I am chairing a panel with no panelists in the room, and so it's great to see my panel here on the screen. These are leading lights in their fields. I will say, just by way of introduction, since I direct the Cyber Policy Center here, some of the ways that I think I think about these questions is to really focus on what is different in the new technology when it comes to, in this case, we're talking about, say, constitutional and criminal justice issues. I think whenever I give a talk on cyber policy, I always get three responses. The first is, what I think is bad is actually good. The second is, what I think is new is actually old. And the third is, what I think is original is something you've published on already. And so I'll say that in thinking about VR and its impact and its relevance for criminal and constitutional questions, we were joined last night by the founder of Second Life. And I think a lot of the questions about whether it's harms or legal issues that come into play in the VR experience, many of them were happening on desktops 20 years ago. And so, yes, you can commit fraud in VR, and we'll have a lot of, in a virtual world, and we'll pay a lot of attention to that, but you can commit fraud through normal computers as well. And so thinking about what it is about the new experiences that lead to novel legal questions is, I think, the way I sort of jump into this. And so, as Britton mentioned, we've got three panelists who come from sort of very different perspectives on this. I will throw out some questions, I think, and have them jump in. Eugene, if it's okay, I'd like to start with you. Sure. You and Mark Lemley wrote really a survey piece a while ago looking at, I think, legal issues with respect to VR. What do you see as the sort of primary legal questions or new legal questions that are sort of coming up in virtual and augmented reality environments?
Right. So in general, throughout my law and tech career, ever since I started writing about the internet back in 1995, I've always generally assumed that a lot of the things that are going to be happening are going to be largely technology invariant as a purely legal matter. And it's generally been right. Obviously, there's some statutes that focus on the internet, but look, libeling someone online, setting aside Section 230, so let's assume it's a lawsuit against the person who actually posted it, it's pretty much the same as libeling them in print from a legal perspective, or by fax, or by skywriting, I suppose. However, it turns out that what really makes a big difference, where the technology makes a really big difference, is how we enforce these rules. So enforcement mechanisms that used to not work very well may work better, and more often enforcement mechanisms we kind of made do with in the past may end up spectacularly failing in many respects. So let's think about it in the context of VR and criminal law. And what I want to highlight is two important factors for people to remember about when they think about crime online. And let's set aside crime like fraud and such, where I do think that the analysis may end up being pretty much the same as in the existing world. So one is what I call the Bangladesh problem. So Bangladesh is a very populous country. It's one of the 10 most populous countries. It's also almost literally half a world away. So let's say that you're walking down a VR street and something bad is done to you. Now, in many situations in the world, it's very hard to get anything to happen about that. Let's say somebody is getting in your face, like physically comes up to you in a menacing way. Or let's say somebody gropes you. Or let's say somebody starts shouting. By the time you call the police, it maybe the person is long gone. But at least then they are gone. So at least the problem has in some measure gone away. But if you're in VR world and somebody, let's say, exposes themselves to you, let's say a claim is it's indecent exposure, their avatar is naked, or the avatar shows itself masturbating, let's say, or the person is shouting very, very loudly in a way that interferes with with whatever the experience you're trying to have in VR is. Or the person is coming up and visually trying to grope you. I mean, physically it's not the same, quite unpleasant nonetheless, and quite an intrusion, a psychological intrusion. And you call up the police and they say, this crime is happening. Where is it happening? Oh, in VR. No, really, where? Oh, in virtual reality. And even if the police officer says, okay, fine, I understand there could be crimes there. Well, where is this person? Oh, that happens to show up in his avatar. He's in Bangladesh. I think many police officers will say, I'm not sure that I can do much to help you about that. I mean, I suppose we could try to get in touch with the Bangladeshi authorities. I suppose we could get the person extradited for indecent exposure from Bangladesh. Doesn't seem very likely to succeed, right? And Bangladesh is just a stand-in for a country that is far away, that is probably unlikely that there's going to be kind of routine criminal law enforcement action in this situation. Now, of course, this is always a problem in many contexts, right? It's all been long a problem with fraudulent emails and such, of course, because of communication technology. Just VR. On the VR street, there's every reason to think that very many people will not be from your country, certainly not from your city or your state. This could be, in some respects, even a Nebraska problem. Like, would somebody from the LA Police Department really reach out to Nebraska to try to figure out what seems like a relatively petty crime? The other factor that I think is tremendously important is technologically enabled self-help. And people have talked about it, for example, with regard to VR groping. That if you have a well-designed VR system, it may have a bubble where somebody can't visually, and certainly not haptically, reach out to you, or can't visually appear within more than 3 feet, within fewer than 3 feet or fewer than 6 feet of you. If the person tries to do that using his VR headset, it just doesn't record this way. It doesn't look like this person is groping you, because in the VR sensescape that VR is creating for you, it's technologically set up so that you can't be touched, at least maybe setting aside the people on your hug list. Like, you could have a list of people you want to be hugged with or more. But that's something, unfortunately, the real world, if only the real world provided these kinds of features, that would be great. But the technological world could. And the goal should be to try to get these things implemented. Likewise, if we're worried about people with avatars that are naked, or again, even if you say, well, public community is not such a big deal in VR, okay. Well, imagine again, there are avatars which are displaying themselves masturbating or having sex or whatever other things that really, in the physical world, would be seen as quite intrusive. Well, this is something that presumably the avatar designers or the VR environment designers could deal with. They could say, look, here's a button, and this button will convert the avatar into a big blue blob. So you'll still see there's someone there, but whatever details they want to show you, either nudity or swastikas or hammer and sickle or whatever other things you may find offensive, you are technologically enabled to protect yourself without the need to bring in criminal law enforcement. So I think our goal in VR ought to be to try to figure out these technologically enabled self-help, because I think the actual criminal law enforcement is likely to be even harder. Not that it's easy these days to get the police interested in crimes against you in many situations, but it's likely to get even harder.
So, Joe, I want to turn to you on the criminal law issues, but I want to start with Amy first on sort of what you're thinking about, because I think in the privacy space that maybe we are dealing with both differences of kind as well as degree in thinking about VR. I want to see if you sort of agree with that. What is it that you see the new technologies, sort of what problems do you see them posing that are sort of characteristically different from other digital technologies, other sort of use of the internet, the sort of long history? There's certainly no shortage of privacy violations that people allege in the current environment, right? So what changes in the virtual environment?
Sure. Thank you for the question. I also want to start with thanking Britain and the organizers of the event and apologizing for being on screen. I was really hoping to be there in person, but ended up feeling a little bit ill, and in this environment, not wanting to expose anybody to that. But if I have to go on mute to cough, I'm also going to apologize because that very well might happen. The funny thing is Eugene just introduced a concept he called the Bangladesh problem, and I've had direct experience with that. So I want to just give a +1 quickly to that. A while ago, I was speaking at an event in New York. This was several years ago. and I received via email at my office in Washington, D.C., where I received the email being an amorphous thing that you could receive anywhere, a threat against the event. And so I called up the correct line for the New York police to let them know I had received this so they could do whatever they wanted to do to investigate or not. And they were like, no, you don't call us. You call the DC police because you're in DC where you received the email. And it was a moment of just total disconnect for me of that's not what they should be doing. And I ended up calling the DC police and they came over and they're like, we have nothing to do here, and took a statement and left. So this was not all that long ago, but shows the very low preparedness that I think law enforcement has for technology, even as we understand it today, let alone where it's going in the future. I do think there are a lot of things we need to think about, and I want to focus specifically on the degree to which technology is going from, I would say, a blurred line between what is digital and what is real life to complete integration with extended reality. We are no longer having lines that exist whatsoever, blurred or otherwise. And so where maybe traditionally, many of us have seen in our lifetimes a movement from having actual filing cabinets. I mean, some people in the room might not know what a filing cabinet really is or have never seen one in person, but filing cabinets in your home where you keep important documents and filling out your tax forms in paper, having real checks that you take really down to a real bank and you put in a pneumatic tube and it goes into the bank and the teller puts that check into your account, like actual paper physical things. And now we have cloud services and servers and digitized contact books. We take photos of our checks to deposit them remotely and we never see a bank. When we see checks at all, a lot of times things are just purely digital. And we use online services for even our most sensitive transactions. That said, we still do have in-person contact points. And I think with VR, we're seeing, again, those even in-person contact points fading away, or at least molding unrecognizably with the digital in the future. And where does this impact our criminal and constitutional analysis? Well, to greatly oversimplify, and I'm going to try to oversimplify quite a bit because, first of all, some of you probably know a lot of this already because you have been studying either constitutional criminal law or you're law professors more generally, but also because I want to get to the conversation. I don't want to take up too much time. So oversimplifying, the Fourth Amendment says government shouldn't invade personal space, persons, houses, papers, effects. For those of you who did your homework and listened to the video on the website, you'll see some of the overlap with Jeremy's concept of persons, places, and things for what is extended reality. And since the 1960s, this has meant that you generally have protection in places where you have a reasonable expectation of privacy. However, the 1970s came along and you got a big asterisk to that, which essentially said that you don't have an expectation of privacy in material you voluntarily turn over to a third party. So at the time that was phone numbers and bank records. Today, it's a lot more. In the future, it's going to be everything. Everything will be routed through a third party. And so to me, that gives the criminal and constitutional analysis for when law enforcement gets into the question of investigating crime in XR a huge, it hugely changes the game. And we're going to have to respond to that changing the game. Now, there are two ways I think we're going to see in the US a response. The first is through the Supreme Court and through court decisions. We know from most recently in 2018, the Carpenter case, that the Supreme Court keeps kind of chipping away at this third-party doctrine. That case very narrowly held that cell site records of location were not within the third party, but more broadly kind of set forth this test about intrusiveness and the nature of documents. We're going to, I think, see it take quite a long time for us to address all the specific cases needed in holding with the courts policy of not going further than the cases in front of us, of deciding, cases and controversies, to see that third-party doctrine narrowed appropriately for extended reality and how much information is going through other servers and other systems. But that is one route that we are seeing taken and we should be looking at. The other is statutory. Arguably, we will have a Congress one of these days again, and Congress can provide additional protections beyond the Constitution. Things like we see in the the Wiretapping Act or the Stored Communications Act, which arguably go beyond and pick up for protections that are not necessarily within the Constitution. So I think these are two areas where in this field we need to be talking about them early and often in regard to where extended reality is going to move the ball on these areas. I also, real quickly, if you'll give me just a little bit of latitude, want to throw out 3 questions that I don't necessarily know the answers to, but I think we're going to need to answer. One is, where does extended reality become a tool for investigations when law enforcement actually go into extended reality to conduct investigations? We're already seeing the use of social media, law enforcement using profiles that either intentionally or consequently obscure their identity as law enforcement officers. What will that mean? How does crime change in extended reality? I think Eugene introduced this a little bit, but I think we're going to see things that feel like crime, feel like harassment, feel like assault, but don't necessarily look like assault in the way we traditionally think assault looks like, and actually don't qualify as assault in the way a lot of states have their criminal laws written. So do we need to change our expectations? And in some cases, we need to change our criminal laws to make sure we're taking account of where crime might go in the future. And the final question I have is, what happens when things go wrong? The primary remedy for violations of the Fourth Amendment is having information or having evidence withheld. But we might not know always where information was gathered in violation of the Fourth Amendment. We have things like parallel construction or not even relying on that evidence. And I think we should be looking at consequences for bad behavior when you aren't sure where the source of the information is coming from. So thanks for letting me tee those up. I have a lot of things here, but I do want to get to the rest of the conversation.
Thanks. Joe, in your life and in what you're doing, how do you see VR and AR and XR as different than the norm, whether it's computer crimes or areas where we've been sort of talking about it in the desktop and mobile sense as opposed to the, say, headset sense. What do you see as the unique challenges, if any, that extended reality is posing, in the arena that you work in?
Sure, thanks. And if I could begin just by kind of giving the usual caveats that I'm here just speaking for myself, and what I say may or may not reflect the official position of the government. But I'm grateful to be here, and I thought I'd like to commend to everybody for interesting and thought-provoking, and I've got a question that I want to kind of ask him in particular about the kind of federal role in particular that might exist in criminal law enforcement in the VR context, and in particular, what he might think about the Computer Fraud and Abuse Act as recently construed by the Supreme Court in Van Buren. But I'll explain that question in a second, but I want to just quickly circle back to the third-party doctrine. And I really liked your summary of that. It was exactly right that the Supreme Court, since the 1970s, has had this third-party doctrine that basically provides that the Fourth Amendment allows the government to obtain without a warrant, with process that requires a lower showing, information that an individual voluntarily discloses to third parties, and the key cases from the 1970s that established this in the context of bank records and of telephone call logs. And for a long time, that doctrine was also accepted as applying sort of all across the technology landscape with all the information that electronic communication service providers increasingly gather, and including the very important location information that people's cell phone companies collect. And for up until the Supreme Court's decision in 2018, that information was available to the government through what we call in the business a D order. Section 2703D of the Stored Communications Act allows the government to get an order to serve on the cell phone provider for that location information with a lower showing than a probable cause warrant. And so the government did that in the case called Carpenter, and it went up to the Supreme Court, and the Supreme Court decided that the carve out from the third party doctrine for 7 days worth of cell site location information. And the reason that they gave for that is interesting, because it seems to me that there's kind of two ways of thinking about Carpenter. One of them is to say that the Supreme Court, without saying so, basically killed the third party doctrine, and the third party doctrine is kind of this walking zombie. And the other way to read it, and the way that the Justice Department is going to try to advance going forward, is that no, the Supreme Court has this very narrow carve out from the third party doctrine for this particular kind of data, and that the doctrine in other contexts continues to be applicable. So what the court said about this, about the carve out that it created, was that individuals have a reasonable expectation of privacy in their physical location and movements, in the whole of their physical movements over time. And the court repeatedly used the word physical. And they said that because of the nature of these records is different from all the other kinds of records that we are constantly disclosing to third-party communications providers, it's that these records enable a kind of comprehensive, near-perfect surveillance of everywhere we physically go in the physical world. The court said, as if there's an ankle bracelet attached to us. And the court also said that this disclosure isn't really quite voluntary in the same way that the bank records and the phone records were, because you don't kind of affirmatively say to the cell company, I'd really like you to track wherever I go. Instead, you just keep your phone. What you really want is to just have your phone connected to whatever is the appropriate cell tower. And as an incident to that, the company keeps track of where you are so they can provide you with that connectivity. But the court says that so that you aren't really kind of expressly agreeing to have your location tracked. Instead, you're just turning on your phone, and the alternative to having your location tracked would be to just disconnect your phone. And the court in Carpenter said that having a phone is sort of indispensable to fully participate in modern life. And so we don't want, it's not really completely voluntary, this location information that you disclose. And so, okay, so with that rationale in mind, what are the kinds of arguments, assuming that more and more of life happens in these virtual spaces, people spend more of their time and do more of their transactions in virtual reality, and the providers that provide those services have digital location information and other relatively comprehensive information. And so defendants are going to make arguments that this information is increasingly looking like the near perfect surveillance that the Supreme Court found in Carpenter justified a carve out from the third party doctrine. And the government will have to argue that there's still something special about physical space. And that's why the court used the word physical in Carpenter. And even if you do a lot of things in virtual reality, you still don't do everything there. It isn't analogous to a phone that you have with you all the time. Eventually, you take those, the goggles off and go places in the real world. And so we'll have to, I think that's the terrain in which the arguments will occur is there something still special about physical location that makes it subject to the third party doctrine carve out, whereas the kind of logs that are generated in virtual reality are still just what you do electronically, digitally, and it's still those kinds of logs are still subject to the third-party doctrine is the argument that we'll have to try to make. And in addition, we'll have to try to say that participation, that disclosure is still sort of more voluntary, less kind of indispensable than the kind of cell phone use that the Supreme Court talked about in Carpenter. Okay, so that's I think where I see these kind of third-party doctrine arguments going forward, and where it will go, I don't, who knows, but that's the way I see that that argument playing out. So for Professor Volokh, I just wanted to, his article was great in discussing the kind of limits of criminal law enforcement possibilities in this space, and I completely agree with what he said about the Bangladesh problem. I guess my only response to that is to say that we do in the government, in the federal government, try really hard to develop and maintain good relationships with our overseas partners. And I work particularly in the ransomware context where that Bangladesh problem is the problem, and we try hard to be able to bring those actors from overseas, but it's a huge problem. If they're in Russia, it's as increasingly they are. It's just kind of like, I don't know what we're going to do about that except keep trying and hope they travel. But what I wanted to ask him about was the Computer Fraud and Abuse Act, Section 1030, is a sort of potentially, at least, a pretty big, powerful tool that could be used against a lot of the kind of malicious activity that Professor Volokh's article describes. And let me explain why. So that statute prohibits unauthorized access or exceeding authorized access of a computer. And so in theory, that you could have, there's all these puzzles about, okay, you do something malicious to somebody, but it's in virtual reality. So was there consent? Was it in the context of a game? Was it really a crime? Did it really do harm to a real person as opposed to an avatar? A lot of those issues can kind of go away if the criminal conduct is basically doing something in the computer that's against the rules of the computer. And as long as you do that in furtherance of even a tortious act, or you damage the computer, or you obtain information that you weren't supposed to get, then that can be a serious federal felony. However, there's a potential obstacle to that kind of very broad use of the Computer Fraud and Abuse Act, and that's the Supreme Court's recent decision in Van Buren, where I assume everyone's familiar with that, but just the basic gist of it was that that case officer
Joe, you're freezing, so I'm going to turn to you.
Had access to a license plate database, and he had a friend who said, "Hey."
Sorry, you've been freezing in and out. Let me turn to Eugene. I think we've got the gist of the question. Eugene,
Sure.
do you want to talk a little bit about that? And I also want to open it up if people have questions in the room, since we've got about 9 minutes left.
Sure.
Yeah.
As usual, there are two dimensions here. One is, what's the formal legal rule? For example, again, let's say that I show up in some virtual environment with a naked avatar. And let's say it's a violation. Let's assume it's a violation of public indecency laws under the laws of the relevant state, whatever that state might be. And there are interesting First Amendment questions, whether VR indecency is constitutionally protected speech rather than unprotected conduct. But let's assume this is so. And let's assume that I'm also violating terms of service, which say you can't have naked avatars. Well, under Van Buren, and I think that is probably the best reading of the Computer Fraud and Abuse Act, the mere fact that I am using the computer in a way that's contrary to the authorization I was given by violating the terms of service, that's not a violation of the Federal Computer Fraud and Abuse Act. Maybe a violation of state law, although again, query what can be done about it, but it's not a violation of the Computer Fraud and Abuse Act. Now, maybe if I exploit some possible bugs in the software in order to be able to access your avatar and kind of change your avatar and put embarrassing things on your avatar, put kick me on your avatar or something like that, maybe that might be a violation of Computer Fraud and Abuse Act, because I'd be accessing material that I'm forbidden to access by some sort of hacking, let's say. But I don't think that simply violating the terms of service is a federal crime, and I don't think it should be a federal crime. That's a breach of contract, but not a federal crime. But again, setting aside the formal legal question, my question is, how many federal prosecutors are going to actually, if somebody complains, oh, there's this nude avatar, again, even worse, some avatar that's, say, masturbating or depicting some sex act, or there's somebody who's shouting very loudly and interfering with people's VR experience, which would be breach of the peace under ordinary state law. But let's say they could argue it's a violation of the Computer Fraud and Abuse Act. How many of them would actually prosecute that? My understanding is it's not easy to get federal government to prosecute unless there are missing millions or dead bodies and federal jurisdiction or kilos of cocaine, right? Ordinary street crime historically has not been a federal matter. And even if it is formally possibly subject to federal authority, federal prosecutors, there are too few of them to go after every one of these items. So I think the question has to be, what can the VR platforms do to improve the experience for the users through providing technologically enabled self-help? We should not count on criminal law enforcement except when it's necessary for things like frauds, which could be very difficult to deal with, for especially massive frauds. But to the extent that we're just sort of hoping the feds will come in, the U.S. Attorney's Office will come in and solve these equivalent of VR, let's call them VR street crime problems, I just doubt that they will. Even if they should, and I'm not sure they should, but even if they should, I doubt that they would.
In the last 5 minutes, I want to open it up in the room. We've got a question here on the left, and I'll repeat it just in case people can't hear.
Thank you. This has been really great discussion. My question is, of course, it's application of the current law as it exists. Globally, it doesn't matter. Varieties of laws and enforcement mechanisms are there all over the world. But then, do you anticipate brand new areas? There's no law that exists today because digital world operationally, behaviorally is very, very different environment than the physical environment and how we even define an assault. So is there even an active discussion from a justice point of view or a constitutional point of view or a criminal point of view as to scenarios like a sci-fi version, what are the possible scenarios where we can start architecting some new laws as it unfolds and then see and test it out? That's one. The second one is, do you also see the integration of AI playing a much bigger role, which is artificial intelligence? Because if you're dealing with data information, majority of the actors don't have to be human actors impersonating as an avatar, but can be bots, again, not in the way we define bots, but truly, entirely operating, because for large amounts of data, it's not humanly possible, hence we do need the AI help in even monitoring and administering these kind of justice kind of scenarios. So those are two broad questions. I just want to open it up and get your points.
Amy, did you hear the question? I thought maybe I'd turn to you first, and then if others have something to jump in.
I want to focus on the first part of the question because I think there's something here about looking at where the laws are that actually goes back to the conversation we just had about computer crimes versus the other types of criminal law. I, in a previous life, worked on a survey of laws in the US, and I do recognize this is a global issue. This technology is going to be used all over the world. We need to have this conversation about laws all over the world. But I was looking at Internet of Things security issues when they could be broken into and used in ways they weren't intended. And actually looking at a specific category of Internet of Things products that were used in intimate settings. And we were looking at sexual abuse and rape laws to see if those were used by people who were not intended to be the users of them, if they would qualify in US state law. And the mix of when they would qualify as a violation of the sex crimes as opposed to computer crimes was very varied. Sometimes it would, if you looked at language in a certain way, and sometimes it wouldn't. And the reason I'm bringing up this category is because I actually think there are really important reasons when you're violated in certain ways for a criminal to be pursued under certain crimes as opposed to being pursued under computer crimes. There are violations that you suffer and ways to recover from those violations that I think are bolstered by seeing the person responsible for those harms brought under certain types of prosecutions. And so looking at where laws address the harms that we're going to see in the digital world early when we know that those harms are going to take place, we know people will be violated in certain ways and feel certain types of harm, is going to be really important. And I think we really need to be doing a comprehensive survey of criminal law today before we get to that place, and figuring out if they do qualify. Because again, I think my personal opinion is that we're extending computer crimes well beyond where computer crimes should be extended in many circumstances. And I'd love to see us rely on the actual underlying criminal law wherever we can, but sometimes that's not going to live up to the situation. So I think we do need to do those surveys today, and it's really important that we get to those issues.
So I'll say, oh yeah, Eugene, what do you want to say?
Just briefly, Eugene, tremendously important, but one thing to keep in mind, for some people it's always in mind, but sex, right? Sex is going to be a killer app for VR. All sorts of things, both VR porn and VR sex. It could be VR sex in the context of existing committed relationships. Spouses are half a world away physically because of work or whatever. They want to maintain a relationship, and especially if you have haptics, essentially. Think of smart vibrators and various other things. That's just the tip of the iceberg. Think smart condoms, all sorts of other instrumentation. I'm sure top people are working on it already. This is going to be hugely important. It's going to be also important for casual sex, and it's also going to be important for all sorts of things are going to happen here. And inevitably, there are going to be hackers who get their jollies, sometimes by lifting the visual images from all these things, but also sometimes precisely, I want to hack into somebody's vibrator and do things with it precisely because in that situation, precisely because this is unwanted, precisely because you want to exercise power over someone that way. Now, I'm not at all a criminal law abolitionist. I'm all in favor of throwing the book at people, and those people would deserve to have the book thrown at them. It would be interesting to see what book it would be. So that was Amy's point. At the same time, we have to understand realistically the limits of enforcement in this kind of situation, especially with great distance. It's not like we're great at enforcing sex crimes law as it is, even in the physical world. Now, to be sure, here, you may be able to track people down, although it may be pretty easy for people to hide their identity. But in any event, when they're half a world away, maybe you could get people extradited for that. That's not the way the smart money would bet, I think. The really important question as to all of these tremendously significant things is how can we figure out really good security systems? Again, security systems that in the physical world, regrettably, are not available. But how can we figure out ways of technologically preventing this kind of hacking and reducing the harm of the hacking, having some sort of mechanism, maybe they can break in some measure, but at least before they actually take control of the vibrator, you can stop that, or you can kind of interrupt the event in some situations, whatever else. Those would be the things we should be looking for if we really want to prevent the harm. Now, if we want to punish the harm, I'm all for that as a matter of moral principle. I just think as a practical matter, it'll be often so difficult that this is an area we should be investing a tremendous amount of prevention rather than relying on after the fact punishment and whatever deterrence it might bring.
So, Justin, I think you've got a question back there. This will be the last question, and Joe, I want to make sure you feel go back to you if your video is working.
Yes,
yeah.
And I'm just representing questions actually from the online audience.
Oh, great.
Actually, one's more of a comment from Herb Lynn. For Eugene, one could also imagine more vigorous capabilities for a victim to respond. For example, one could introduce a swift kick in the groin as a response. That is, VR enables a much broader range of self-help measures than is possible in the physical world. Would love to hear a reaction to that. And then Nathaniel says, the Bangladesh problem we're discussing is really an internet problem rather than a VR-specific issue. Any distributed computing solution suffers from it, and it's one that law enforcement has been grappling with for some time. What are the aspects of XR that exacerbate this problem or ways that it is particularized in the context of VR beyond simply being an internet problem?
Yeah, that was where I wanted to push things a little bit. But Eugene, what did you just say? Sorry.
I want to give you a very quick response. I love the idea of a swift kick in the groin of the groper or the masturbator or whatever else, but they're not idiots, right? If they have haptics on their VR setup, they will presumably have the haptics set up to disable the swift kicks in the groin. Now, some people actually recommend, look, even if just the victim can feel like she's swiftly kicking someone in the groin, even if that just sort of appears in her sensescape, that's at least something. But we have to expect that as criminals generally, that they're going to take proactive countermeasures. And so attempts at self-help through hacking into the other person's haptics or just triggering the haptics to make them feel the pain, they're going to deal with it by just not connecting their haptics that way, I think.
Joe, did you want to have any final comments here?
Sure. Just really quickly to say, it sounds completely right to me what Professor Volokh is saying about the need for these technological barriers to the worst of the criminal activity. And the point that I was trying to make about the Computer Fraud and Abuse Act would be that if they create the right kind of barriers, then transgression of those barriers could result in a federal offense in the circumstances where the conduct is so serious that federal prosecution, it's consistent with the principles of federal prosecution to bring a case. And then just in response to what Amy said, I would just say that, sometimes in the prosecution business, we just have to use the tools that are available to us, especially at the federal level, the ones that give us the federal hook to, so we often will have to use gun statutes when we're talking about, the underlying conduct is not really that. And the same thing with computer crime, we do the best we can.
Great. Let me just spend 1 minute. I want to throw just some ideas out on the table that I don't think we covered, but I want, and then we'll split for coffee. Which is, I think there are some areas, if I had on my list of things where VR poses novel questions that are different from just the internet. One of them, and I should direct this to Eugene for a future conversation, something about, for example, traditional public forum analysis in the First Amendment. What do we think about virtual streets and roads, and how should we think about, obviously, and these are privately governed universes right now, but that's in part of the question, and Eugene's written actually quite, I think, well about, the degree to which even current social media platforms are sort of like places of accommodation or public utilities and things like that. The second is takings of virtual property, so that if the government is taking, your real estate in a virtual environment, does that implicate takings law? And then the last is a series of things I think Amy was gesturing toward, which have to do with criminal procedure and what are reasonable expectations of privacy in a virtual world as opposed to in the real world, because I do think that those are situations in which, right, we haven't quite defined what's sort of the nature of your expectations and your privacy rights in the virtual world, and we'll have to draw boundaries between what governments have historically been able to do and what they can do in the virtual world. I will end it there. Thank you so much to our panel. Thank you all to the audience, and we'll break for coffee, and we return in 8 minutes.